So, Donald Trump just suffered what legal experts are calling the most crushing courtroom defeat of his career. The federal judge overseeing his criminal trial denied his emergency motion to halt proceedings, and she did it in a way that absolutely demolished every argument his legal team presented. We're not talking about a dry procedural ruling. This was a 47-page written opinion that systematically destroyed Trump's claims, questioned his attorney's ethics, and suggested that the entire emergency motion was filed in bad faith to delay justice. Trump's legal team filed what they called an emergency motion for mistrial based on alleged prosecutorial misconduct, jury tampering, and judicial bias. They demanded an immediate halt to proceedings, claimed Trump's constitutional rights were being violated, and insisted that continuing the trial would be a miscarriage of justice. They filed it late on a Sunday night, demanding a Monday morning hearing, creating what they hoped would be a chaotic scramble that might force a delay. But guess what? Judge Sarah Chen was ready for them. She not only denied the motion, but she also issued a written opinion that reads like a prosecutor's closing argument against Trump's entire legal strategy. She found that the emergency motion was frivolous, that the claims of misconduct were fabricated or wildly exaggerated, and that the real purpose was delay and obstruction. It's honestly hard to believe she put it all in writing. This isn't just a loss for Trump. We're talking about a federal judge essentially accusing his attorneys of abusing the legal process while the entire legal community watches. And trust me, when a judge goes this far in a written opinion, it means she's done playing games with a defendant who has been testing her patience for months. Let me fill you in on what's been happening. The trial has been a disaster for Trump from the opening gavel. The prosecution has presented a mountain of evidence, including documents, recordings, and devastating witness testimony. Trump's defense has struggled to land meaningful punches, with their cross-examinations often backfiring and their objections being routinely overruled. From the get-go, it's been clear that the evidence against Trump is overwhelming, and that his legal team is scrambling for any strategy that might change the trajectory. But here's where the rubber meets the road. According to Politico's December 6 report, Trump's attorneys filed their emergency motion at 11:47 p.m. on Sunday night. The motion, which ran to 183 pages with exhibits, alleged that prosecutors had committed misconduct by allegedly coaching witnesses, that jurors had been exposed to prejudicial media coverage, and that Judge Chen herself had displayed such obvious bias that no fair trial was possible. They demanded that she recuse herself, declare mistrial, and potentially dismiss all charges. This mess is unfolding because Trump's legal strategy has shifted from trying to win on the merits to creating chaos that might generate grounds for appeal or delay. According to legal experts who spoke with CNN, the emergency motion contained allegations so extraordinary that if true, they would indeed require drastic action. The problem is that none of them were true. And before we go any further, let's be real for a second. Emergency motions are serious procedural tools reserved for genuine emergencies that threaten irreparable harm. They're not supposed to be used for last-minute hail, merry attempts to disrupt trials that aren't going your way. Now, back to the matter at hand. Here's where it gets interesting. Judge Chen scheduled a hearing for 8 a.m. Monday morning, giving prosecutors just hours to respond. According to courtroom reporters from CBS News, the atmosphere in the courtroom was electric when proceedings began. Trump was present, looking confident, clearly expecting that his emergency motion would at minimum create delay and distraction. The prosecutor stood first and methodically demolished each claim in Trump's motion. She noted that the alleged witness coaching was actually the standard witness preparation that occurs in every trial. She pointed out that the claims about jury exposure to media were contradicted by the jurors' own statements during daily questioning, and she spent considerable time addressing the allegations against Judge Chen, noting that every ruling Trump's team characterized as biased had been legally sound and thoroughly explained. Then came the most devastating moment. The prosecutor presented evidence that Trump's own legal team had leaked information to the media specifically to create the prejudicial coverage they were now complaining about. Phone records showed one of Trump's attorneys had been in contact with reporters from 2 networks just hours before stories appeared that the defense now claimed were tainting the jury pool. Essentially, Trump's team had manufactured the emergency they were now asking the judge to remedy. They had created the problem, then filed an emergency motion blaming everyone else for the problem they created. Judge Chen then delivered what observers described as one of the most blistering judicial rebukes in recent memory. According to reporters from multiple outlets who were in the courtroom, she did not hold back. She called the motion an abuse of the judicial process. She noted that the factual claims were either completely false or grotesque mischaracterizations, and she reserved particular criticism for allegations about her own conduct, noting that suggesting bias without evidence was a serious matter that could subject attorneys to sanctions. This announcement sent shock waves to the courtroom because judges rarely speak this bluntly about attorney conduct. The fact that Judge Chen was willing to be this direct and this critical in open court suggested she had reached the end of her patience with Trump's tactics. Now, this isn't the first time we've seen Trump's legal strategy involve last-minute emergency motions and allegations of conspiracy. This pattern of throwing legal hand grenades when trials go badly has manifested repeatedly throughout his legal troubles. Just think about how Trump's team handled the New York civil fraud trial. As the evidence mounted and testimony went badly, his attorneys filed emergency appeals attempting to halt the trial. They claimed bias. They claimed persecution. They accused the judge of prejudging the case. Every allegation was rejected, and the trial proceeded to a judgment against Trump of over $450 million. Then there was the Jean Carroll defamation case. Trump's attorneys repeatedly sought delays, filed motions claiming the case should be dismissed, and made allegations about the process that judges found without merit. Trump even violated a court order by posting about the case on social media during the trial, leading to additional damages. And let's not forget the classified documents case before it was dismissed on technical grounds. Trump's legal team filed dozens of motions attempting to delay trial, many of which the judge found frivolous or redundant. The strategy was transparently about running out the clock rather than addressing the underlying evidence. Even in the January 6 case, Trump's attorneys attempted emergency appeals all the way to the Supreme Court, seeking to delay trial through claims of absolute presidential immunity that legal experts described as having no basis in law or precedent. Now, it looks like Judge Chen has decided she's not playing that game. The written opinion she issued makes clear that further delay tactics will be met with sanctions, not patience. So what specifically did Judge Chen include in her written opinion that's causing such humiliation for Trump? Well, it goes far beyond just denying the motion. She used the opportunity to create a record that will haunt Trump's appeals and potentially his attorneys' careers. According to CNN, which obtained the full opinion, Judge Chen spent 30 pages systematically addressing and demolishing each claim in the emergency motion. On the witness coaching allegation, she noted that prosecutors are not only allowed but also ethically required to prepare witnesses. She pointed out that the defense had engaged in identical witness preparation, making the complaint hypocritical as well as baseless. On the jury contamination claims, she noted that jurors are questioned daily about media exposure and that not a single juror had indicated exposure to the specific coverage Trump's team cited. She went further, presenting evidence that Trump's own team had leaked to the media in an apparent attempt to manufacture grounds for mistrial. Now, here's the kicker. On the allegations of judicial bias, Judge Chen was particularly pointed. She noted that she had ruled for the defense on numerous objections and motions throughout the trial. She listed all of the accommodations she had made for the defense, such as extra time for planning and scheduling flexibility. She then addressed each decision that the defense claimed was prejudiced, outlining the legal foundation in a way that made it obvious that any capable lawyer should have been able to comprehend the reasoning behind the decisions. The most heartbreaking part followed. Judge Chen stated that the emergency request seems to be intended to cause delay and produce sound bites for political consumption rather than to address valid issues. She pointed out that filing at 11:47 p.m. on Sunday, requesting action on Monday morning, and containing 183 pages, implied that pandemonium, not justice, was the intended outcome. According to her, such strategies, quote, damage the reputation of the legal profession and erode public trust in the legal system. That phrase, according to legal analysts on MSNBC, is the closest a judge can get without using the exact term to describe lawyers as dishonest. It's a declaration that will be monitored by Trump's legal staff and may play a role in barred disciplinary actions. Trump's team has responsibilities to the court and the legal system in addition to their authority to file papers defending their client. It is evident from Judge Chen's judgment that she feels such duties were broken. This type of written censure is extremely uncommon and indicates that the court feels that boundaries were broken, according to a former federal judge who talked to CBS News. At this point, Trump's legal approach was revealed to be essentially dishonest. There was no emergency. The assertions were unsupported. It was a theatrical move, not a legal one. All of this is now documented in a permanent court record. Then came Trump's response, which in some way made matters worse. He personally attacked Judge Chen on Truth Social, accusing her of being a partisan hack and a shame to the judiciary, and recommending that she be looked into for possible corruption. No fair judge would write something so scathing of his case, he asserted, and the printed opinion demonstrated her bias. However, Trump's camp fell silent when legal experts pointed out that Trump's comments on the judge validate her claim that he disrespects the legal system. Even Trump supporters were unable to explain away the inconsistency between lamenting bias and then brutally attacking the judge. Trump now had to deal with the immediate fallout from this. Judge Chen ruled that Trump must provide justification for his social media posts in order to avoid being found in contempt. She pointed out that assaulting a sitting judge during a trial may be considered obstruction, and that it was no longer possible to overlook Trump's habit of such assaults. Since she set up a contempt hearing, Trump might now be subject to penalties or perhaps a temporary jail sentence. According to some, Trump wants to keep disparaging the judge because it appeals to his supporters and supports his persecution theory. When he challenges authority, his supporters adore him. Conversely, each assault on the judge bolsters the argument for contempt and may have a detrimental effect on the jury. It doesn't help when you need jurors to believe you're innocent because they might decide the defendant has little regard for the court system if they witness him assaulting their judge. The problem lies in the fact that Trump is constitutionally incapable of exercising self-control, even when doing so is clearly in his best interests. Thus, he has put himself in a difficult situation. He has two options: either keep criticizing Judge Chen or risk increasing penalties, which might include jail time for contempt. That would result in the dramatic confrontation he seems to want, but it would also mean that he might be excluded from his own trial. Alternatively, he might halt the attacks and follow the court's directions, which would go against his entire public image and possibly give his base the impression that he is weak. However, that is the only route that keeps him from ending up in a cell. It's a difficult circumstance that is wholly self-inflicted. After being humiliated in a written opinion and filing a pointless emergency motion, he insulted the judge and made matters worse. The entire situation is making Trump's campaign operation completely terrified. The political ramifications are enormous if Trump is found in contempt, punished, and potentially imprisoned during his own criminal trial. If the candidate is detained for contempt, his campaign cannot continue. While swing voters will perceive turmoil and lawlessness, his supporters will be furious. Republicans who have been standing up for Trump are suddenly being asked questions they are unable to respond to. Politico reports that a number of Republican senators refuse to address whether Trump ought to cease disparaging the judge. They clearly understand that Trump's actions are unacceptable, as evidenced by their silence. In the meanwhile, Trump's ruling has shocked legal experts of all political persuasions. Attacking a judge during a trial is irrational and self-destructive, according to lawyers who have defended Trump's legal rights. When the American Bar Association released a rare statement expressing worry about threats on judicial independence, the situation grew even more tense. The time and context made it obvious who they were referencing, even if they didn't mention Trump by name. All parties to a lawsuit, including criminal defendants, have a duty to respect the legal system, the statement underlined. According to legal experts, Judge Chen's written ruling will have an effect long after this trial is over. Former federal prosecutor Andrew Weissman made a speech on MSNBC that ought to grab everyone's attention. This opinion is a roadmap for other judges dealing with Trump's delay tactics, he stated, citing Judge Chen's documentation of the pattern and the legal justification for closing it. When Trump employs similar strategies elsewhere, other judges will refer to this ruling. Take a moment to consider that. Trump's humiliation is now a precedent that will follow him in all subsequent cases. Chen's opinion can be used by judges to dismiss Trump emergency motions. In an appearance on CNN, former acting Solicitor General Neil Katyal characterized the ruling as disastrous for both Trump's appeals and this trial. He clarified that appellate courts have a lot of respect for trial judges and are unlikely to find any reversible error when a trial judge has documented delay tactics so comprehensively. Since this decision involves more than just one denied motion, let's examine what it might signify. It has significant ramifications for Trump's legal exposure, his electoral prospects, and his capacity to carry out his dependable delay strategies. The immediate trial impact comes first. The trial will start right away because the emergency motion was totally rejected. According to Judge Chen's ruling, any further attempt to delay will result in penalties rather than consideration. Now, Trump's legal team is aware that pleading with this court won't work. Trump will be held immediately accountable for his insults to the judge as a result of the contempt proceedings. Whatever justification they were attempting to make is overshadowed if he is found in contempt and sanctioned. Even if he is imprisoned for a short time, the trial proceeds without him, and the jury makes its own judgments regarding his absence. Let's now discuss the implications of this for Trump's other court challenges. Judge Chen's ruling is now available to the public and will be referenced by judges and prosecutors in subsequent cases. The thorough documenting of Trump's delay strategies offers a model for thwarting, like initiatives in other places. Sanctions in other situations where similar strategies are tried may be supported by the conclusion that the assertions were made in bad faith. Trump's capacity to use procedural warfare to run out the clock has been severely undermined. Judges are empowered to swiftly reject delay tactics when they can cite another judge's thorough judgment that found bad faith in terms of the political ramifications. Trump may now be found in contempt during a criminal trial that takes place during a presidential campaign. Swing voters are not impressed by the image of a politician who may be punished or imprisoned for disparaging a judge. Republican candidates will be questioned on if they back someone who has been found to have misused the judicial system by a federal court. It is difficult to write off the written opinions opponents' detailed, documented allegations of bad faith as partisan accusations. Here's the deal, then. A federal judge determined that Donald Trump's emergency motion was frivolous, filed in bad faith, and intended to cause delay rather than address valid issues. In a 47-page written judgment, the court methodically disproved every argument put out by Trump's lawyers. Trump is currently facing contempt proceedings after attacking the judge on social media. Losing a single motion is not the only issue here. It concerns a full disclosure of Trump's legal strategy as theatrical rather than law. It concerns a judge's willingness to put that exposure in writing for the permanent record. The judicial system is now enforcing actual repercussions for actions that have been accepted for far too long if Trump is subject to contempt, fines, or jail time for his attack on the judge. That would indicate that Trump's history of using delay and force to avoid accountability has now reached a breaking point. This trial is only one aspect of it. When one defendant disobeys the law and attacks anyone who attempts to hold him accountable, the question is whether the legal system can continue to operate. Thus, pay attention to this. The hearing for contempt is coming up. The trial is still ongoing. Additionally, Judge Chen has stated in her written opinion that Trump's typical strategies will not be effective in her court. Never in Trump's legal battles have the stakes been higher, the humiliation more public, and the potential for actual repercussions more immediate.